Have you ever found yourself walking through a city and wondered, why is that specific area full of towering apartment buildings, while just a few blocks away, everything is sprawling single-family homes?
Yeah, it's striking, isn't it?
Or why do some communities feel incredibly walkable and vibrant, with shops and cafes mixed right in with residences,
Yeah.
while others are entirely car-dependent, requiring a drive just to grab a cup of coffee?
Right.
These aren't random occurrences, are they? These aren't accidents. They're the result of deeply ingrained, often invisible rules and frameworks that sculpt our surroundings.
Absolutely. It's all by design, or at least by regulation.
Today, we're taking a deep dive into that fascinating, complex, and often contentious world: zoning regulations and urban planning.
Mm,
These are the unseen structures that quietly but powerfully shape the physical, social, and economic fabric of our urban and even rural landscapes.
that's a great way to put it. The invisible architecture.
Our mission in this deep dive is to unpack the fundamental frameworks governing how land is used and developed. We'll delve into their historical roots, understanding why they were created in the first place, their intended purposes, and, the complex challenges of their real-world implementation.
Yeah, the gap between the plan and the reality.
Exactly. Ultimately, we want to explore how these seemingly dry legal concepts have a profound direct impact on your daily life, from the availability of affordable housing to the quality of your local environment, and even the pace of innovation right here in our cities.
It really touches everything.
To guide us through this intricate landscape, we're drawing from a stack of insightful sources, including a comprehensive guide to zoning regulations from the Journal of Architectural Engineering Technology, a fascinating study on the challenges in the implementation of zoning ordinance from Catil in Davao Oriental, a comprehensive overview of comprehensive planning from Wikipedia, and an analysis of the legal framework for smart city governance in India from the Career Point International Journal of Research, along with crucial insights on community participation laws in urban India. A good cross-section of sources there: academic, practical, international.
Yeah, to give us a pretty rounded view. So let's unpack this and start with the basics. We hear the term zoning regulations tossed around a lot, especially when we talk about real estate or new developments. But what exactly are they? They sound technical, almost like legal jargon,
They can sound that way.
but they are absolutely everywhere, subtly dictating the very structure of our towns and cities, influencing everything from where you can live to where you can buy groceries. That's a great starting point, because you're right, they are fundamental. Zoning regulations are essentially the legal frameworks established by local governments to manage land use and urban development. Think of them as the rule book for what can be built and where.
Okay, rule book.
Yeah. These laws divide municipalities, your city, your town, your county, into specific zones: residential, commercial, industrial, or maybe mixed use. And each one of these zones comes with a designated set of rules.
Rules about.
Oh, what exactly?
Well, rules about everything, really. The type of structure allowed: is it a house, an office building, a factory? Its size, its height, the density of development, how many units per acre, for example, and the general use of the structures within its boundaries.
So, like, you can't just build anything anywhere.
Precisely. Imagine a residential zone that explicitly restricts construction to single-family homes. You wouldn't suddenly see a towering skyscraper popping up in that neighborhood. Or consider a commercial zone that permits only offices and retail establishments.
This is zoning at work, ensuring that incompatible land uses don't clash. Preventing factories from being built right next to schools.
Or a noisy nightclub next to homes.
Exactly, that kind of thing. But beyond just preventing nuisances, zoning also plays a critical role in preserving historic areas and protecting green spaces, shaping the aesthetic and environmental quality of our communities.
Okay, that makes sense from a practical standpoint.
Yeah.
It introduces a critical layer of order, preventing total chaos. But what's the underlying philosophy or the big idea behind all these rules? Why did we, as societies, start implementing them in the first place? Was it a sudden realization or more of a gradual shift?
It was definitely a response to pressing issues, driven by a philosophy of orderly growth and public welfare. The primary purposes of zoning are, first and foremost, to ensure the orderly growth of communities. Without it, you'd have chaos, a free-for-all of conflicting uses.
Okay. Orderly growth.
Beyond that, it's about safeguarding public health and safety. Think about the need for proper light and air, sanitation systems, or even making sure emergency vehicles can get through zoning regulations address these kinds of things.
Ah, okay, health and safety. Didn't immediately think of that.
Yeah, it's fundamental. And finally, it's about preserving the distinct character of neighborhoods. It helps maintain property values, manage traffic flow, and ensure that, say, a quiet residential street doesn't suddenly find itself bordering a noisy industrial plant.
Right.
So it acts as a critical tool for urban planning and development by balancing these competing community interests and mitigating conflicts arising from all the diverse ways we want to use land.
This sounds like a concept that grew out of necessity then. It wasn't just dreamed up in a vacuum. Where did this idea of dividing up land for different uses even come from? Was it always this way? Or was there a historical moment or movement that really sparked its emergence?
You're right, it's not new, and its origins are deeply rooted in the challenges of rapid urbanization. Zoning, as we largely understand it today, emerged as a direct response to the chaotic and unregulated growth of urban areas, particularly during the Industrial Revolution.
Ah, the Industrial Revolution. Makes sense.
Yeah, cities were just exploding in population, leading to unprecedented density, often terrible unsanitary conditions, and rampant land use conflicts. Imagine factories churning out smoke right next to homes, or tenement housing packed together with no access to light and air, breeding disease. Zoning was a method devised to try and control this chaos and ensure at least a basic level of public health and safety.
So it was a public health measure initially?
That was a huge driver, yes. But even before formal zoning, there were earlier, though maybe less comprehensive, attempts at planning in the U.S. The sanitary reform movement, kicking off around the 1840s, was a significant precursor. There was this growing awareness of the direct link between disease like cholera outbreaks and ineffective sanitation. This led to early urban planning efforts focused on developing sewer systems and thinking more carefully about town site locations to prevent the spread of illness. And you had figures like Frederick Law Olmsted, the famous landscape architect.
Central Park guy.
That's him. He was a firm believer in this relationship between the physical environment and sanitation. This belief helped lead to the development of grand parks and open spaces in communities, not just for recreation, but for public health, providing fresh air, reducing congestion. But, while it was impactful, this movement wasn't yet looking at the city as a whole, integrated system. It was focused.
Got it. So sanitation first. What came next?
Well, then came the City Beautiful movement, which emerged in the 1890s and lasted into the 1920s. Its origins are famously tied to Chicago and the World's Columbian Exposition of 1893.
A white city.
Exactly. This movement shifted the focus much more towards the design and architectural characteristics of cities. Proponents pushed this vision of the ideal city, characterized by neoclassical buildings, grand boulevards, and beautifully landscaped streets. That exposition showed visitors that cities could be much more than dirty, overcrowded places. It was about civic pride and beauty.
So an aesthetic focus.
Very much so. And this aesthetic movement spread across the United States, influencing the design of many major American cities, aiming for grandeur and order.
Okay, and where does the Garden City idea fit in?
Right around the same time, in 1898, Ebenezer Howard published his hugely influential book outlining the Garden City concept. This was a really visionary idea for planned developments that integrated different land uses, residential, industrial, agricultural, along with community services, all surrounded by permanent green belts. Ample open spaces within the city itself were key.
Kind of the best of both worlds.
That was the idea. These cities were designed to be self-sufficient and to reduce the negative impacts of traditional urban life, combining the benefits of the city and the countryside. And importantly, this wasn't just theory. 2 cities in England, Letchworth and Welwyn, were actually built based on his vision.
Wow, okay.
Yeah, it had a profound impact on city planning thinking globally.
So you have sanitation, beauty, and these planned garden communities. How did this coalesce into what we think of as modern planning?
Well, all these ideas were floating around, and they were really brought into a more cohesive framework by figures like Daniel Hudson Burnham. He was a pivotal figure in American urban planning at the turn of the 20th century.
Burnham rings a bell.
He famously recreated the city plan for Washington, D.C. in 1901, building on L'Enfant's original design. He also created city growth plans for Cleveland in 1903 and San Francisco in 1906. But it was his 1909 plan for Chicago that is widely known as the first comprehensive plan.
Ah, the first comprehensive plan.
Right. This initiated a new movement that aimed to make cities not just more beautiful, but also to function better. That was the crucial shift from merely aesthetic planning to a more holistic, functional approach. Thinking about infrastructure, transportation, efficiency.
Not just how it looked, but how it worked.
Exactly. This truly laid the groundwork for what we now understand as comprehensive planning. But, the question then becomes, how does this larger vision actually get put down on paper and then translated into practice on the ground?
Right. So if zoning is about the specific rules for individual parcels and areas, comprehensive planning sounds like the grand strategy, the bigger picture that ties it all together. What exactly is a comprehensive plan, and what does it entail for a community? It sounds like a massive undertaking.
It absolutely is a massive undertaking, but it's crucial for guiding long-term development. Comprehensive planning is essentially an ordered, long-term process where a community figures out its goals and aspirations for future development. The end product is called a comprehensive plan, though you're right, it's also widely known as a general plan or master plan. Terms vary, but the idea is the same.
Got it. Master plan.
Yeah. And this document explicitly expresses and regulates public policies across an incredibly broad range of topics. We're talking transportation networks, utilities like water and sewer, land use patterns, recreational spaces, parks, housing provisions, pretty much everything that shapes the physical community.
Wow, that's comprehensive.
It really is. These plans typically encompass large geographical areas, often an entire city or county, and are designed with a long-term time horizon, looking maybe 20, 30, even 50 years into the future.
So it's the blueprint.
It serves as the fundamental blueprint, exactly. It establishes the goals, the purposes, it shapes the zoning decisions later on, and it dictates allowed activities on each land parcel, ideally. Its ultimate aim is to provide compatibility and continuity to the entire region as well as each individual neighborhood, ensuring equity and resilience for all stakeholders.
Equity and resilience, those are key themes now.
Increasingly so. And that means it considers everything from existing and proposed land uses and their intensity to their impact on neighborhood character, equity considerations, and resilience or sustainability goals like climate adaptation. It also addresses the protection of various resources, historical buildings, cultural sites, natural areas, coastlines, agricultural land, sensitive environmental zones. Planners look at population trends, demographic shifts, socioeconomic conditions. Traffic and public transportation needs are huge. Utilities and infrastructure capacity, housing resources and current and future needs, and even economic development strategies and tourism potential. It tries to capture this holistic vision for the future.
It's a lot to consider. It's definitely not just about drawing lines on a map. It's about understanding the intricate web of a community's life. So how does a community actually create one of these massive multifaceted plans? Is there a standard step-by-step process that planners follow to bring this ambitious vision to life, from concept to, a tangible document guiding growth?
There is indeed a typical ordered process, although it's important to remember that each step is interdependent and often revisited as new information or considerations arise. It's not always a strictly linear path, more iterative, really.
Okay, so what are the steps, generally?
The process usually begins with identifying issues and stating goals. This initial phase is about pinpointing contemporary issues of concern to residents, workers, property owners, businesses, basically everyone, but it's also about anticipating emerging issues crucial for the future.
So looking ahead.
Exactly. And this is typically a highly collaborative phase. It involves broad community involvement leaders, organizations, ordinary citizens to ensure the planning effort is grounded in real-world needs and reflects collective aspirations. This step sets priorities and guides future decisions. Active participation is key here.
Makes sense. Get people involved early.
Crucial. Once those initial issues and goals are clear, the next critical phase is collecting data. You need a solid foundation of facts. Extensive and robust data collection is vital to evaluate current city conditions, what's working, what's not, and to predict future trends.
What kind of data?
Oh, all sorts. It often draws from government census data, but many communities also collect their own specific data. Common data points include environmental status, air quality, water quality, traffic conditions, economic indicators, social demographics, population growth. income levels, age distribution, public services and utilities capacity, and of course, land use conditions, housing stock, zoning patterns.
Wait,
This thorough analysis leads to critical outcomes like population projections, economic condition forecasts, and assessments of future housing needs. You need this baseline understanding.
okay, so issues, goals, data,
Right.
then what?
Following that groundwork, the process moves to preparing the plan and creating implementation strategies. This stage involves actually drafting the comprehensive document. It typically outlines the current and future conditions based on the data, restates the community goals, and then proposes strategies to achieve those goals.
The how-to.
Exactly. It often includes separate, detailed sections for really important issues like transportation or housing. And within this phase, different programs are conceived to achieve the plan's overarching goals with a keen focus on factors like cost and effectiveness. It's quite common for planners to develop a variety of alternatives to realize a single goal, offering flexibility in approach.
So options are presented.
Usually, yes. These alternatives then go through an evaluation stage. Community leaders, planners, and often the public again, critically assess each option. They look at potential positive and negative effects, impact on the broader community, impacts on the city government's budget and operations. The ultimate goal is to choose the alternative that best meets the needs and desires of the community, balancing all those factors.
Sounds like a tough balancing act.
It often is. Once an alternative is chosen or a consensus plan is formed, the community must formally proceed to adopting a plan. For the plan to take effect as official policy, it must be formally adopted as an official statement of policy. This is typically done by the city council or equivalent governing body, often following extensive public hearings to gather final input and ensure transparency.
So it gets the official stamp.
Right. Once accepted, it becomes a legal statement of community policy regarding future development. It's the official roadmap.
But it doesn't end there, right?
Not at all. The final and really ongoing stage is implementing and monitoring the plan. This involves carrying out the goals defined in the comprehensive plan through various initiatives, projects, zoning changes, capital improvements, etc. City planning staff continuously monitor the outcomes. Are we achieving what we set out to achieve? And they may propose future changes if results are not desired or if conditions change significantly.
Oh, so it's adaptable.
It has to be. This highlights a crucial point. The comprehensive plan is not a permanent document. It can, and often must, be revised or updated maybe every 5 to 10 years, especially in fast-growing communities, to remain current and relevant to evolving needs and conditions. It's a living document, ideally.
That's a truly extensive and iterative process, far more dynamic than just a static document gathering dust on a shelf. So, what does this all mean for the rule of law in urban planning? Is this comprehensive plan a legally binding document everywhere? Where does the authority for all this come from?
That's an excellent question because while the process is ideally very community-driven and organic, its power ultimately comes from a specific legal foundation. The fundamental basis for comprehensive planning stems from the government's inherent duty and right to protect the health and welfare of its citizens. It's part of the police power. This power is typically derived from state planning-enabling legislation. States pass laws that allow or sometimes require local governments to engage in planning. However, it's important to note that in most states in the U.S., local governments are actually not required by law to engage in comprehensive planning.
Really? It's optional.
In many places, yes. State statutes usually provide a legal framework for those who choose to participate, rather than mandating it across the board.
Ah, interesting.
Historically, a couple of foundational legal frameworks influenced this quite a bit. Back in the early 20th century, the U.S. Department of Commerce developed model acts, the Standard State Zoning Enabling Act in the 1920s, and the subsequent Standard City Planning Enabling Act of 1928. These weren't federal laws themselves, but they provided states with models for drafting their own local land use planning legislation and clarified what a comprehensive plan is and how it should function. Many states willingly adopted or adapted these models.
So they provided a template.
Exactly. And interestingly, in states where planning isn't strictly required, governments often provide many incentives to encourage the process at the local level. Financial assistance, technical support, things like that. For example, the source mentions that almost every county in Georgia has voluntarily established a plan, spurred by these kinds of incentives.
Okay, but here's the critical point you raised. Is the plan itself legally binding?
Generally, no. A comprehensive plan is not usually legally binding on its own. for its provisions, its goals, its land use maps to be legally implemented and enforced. A community's specific ordinances, like their zoning codes, subdivision regulations, must be formally amended to reflect the plan's vision.
So the plan guides the changes to the actual laws.
Precisely. The plan acts more as a guiding policy document, a statement of intent, rather than a direct legal instrument you can be sued for violating immediately. The zoning ordinance is where the rubber really meets the road legally.
Got it. And I assume this varies globally.
Oh, absolutely. These principles apply differently around the world, reflecting diverse legal traditions and governmental structures. In the United States, for example, California's general plan, their version of a comprehensive plan, is a long-range blueprint for physical development. And it's quite strict. It has requirements for 8 different elements or chapters, things like land use, housing, circulation, conservation, noise, safety, open space, and importantly, environmental justice, which was added as an official element in 2016.
Environmental justice. Interesting.
Yeah, a newer but crucial addition. And in California, failure to have an adequate, up-to-date general plan could actually result in the suspension of future development approvals, showing it carries significant weight there.
So more teeth in California.
Definitely. There's also a contemporary trend towards green general plans, integrating green measures to promote sustainability, reduce greenhouse gas emissions, improve energy and water efficiency, often complying with specific state environmental standards like California's Global Warming Solutions Act of 2006.
What about elsewhere?
Well, in Canada, comprehensive planning is generally known as strategic planning or visioning, and the resulting document is often called an official community plan, OCP, or a municipal development plan. Similar idea, different name. And in Iran, the City Council of Isfahan, for instance, has a strategy council that developed its final program, reflecting another approach to long-term urban visioning. So the structures vary, but the core idea of long-range planning is widespread.
Okay. So we have this ideal framework laid out, these comprehensive plans that are blueprints for the future. They sound great on paper, but we all know the real world is messy. Even the best plans hit roadblocks, don't they? Where do these grand visions often fall short in practice? What are the biggest criticisms or practical challenges these systems face?
Absolutely. The ideal is one thing, implementation is another entirely. The Comprehensive Guide to Zoning Regulations source highlights some broad, overarching criticisms leveled against traditional zoning, which is often the main tool for implementing comprehensive plans.
Okay, what are the big ones?
For one, traditional zoning, especially Euclidean zoning, with its strict separation of uses, has often been criticized for contributing to urban sprawl.
Sprawl, yeah.
Cities spreading outwards endlessly.
Exactly. Where development pushes further and further out, leading to increased car dependency, longer commutes, loss of open space, and agricultural land. Zoning that mandates large lots or separates housing from jobs and shopping contributes to this.
Okay, what else?
It's also seen as potentially exacerbating social inequality and limiting housing affordability.
How so?
Well, this often stems from the inherent rigidity of traditional zoning practices. Think about zones that only allow large, expensive single-family homes. This rigidity can really stifle innovation in urban design and housing types. It makes it hard to build smaller, more affordable options like duplexes, townhouses, or small apartment buildings in many areas.
Right, the missing middle housing. Precisely. And by restricting housing types and densities, it can perpetuate socioeconomic segregation, effectively zoning out lower and middle-income families from entire neighborhoods or even entire towns. This inadvertently leads to less diverse, less accessible communities.
And that exacerbates inequality.
Directly. As the source notes, restrictive laws in affluent areas often limit affordable housing opportunities for lower-income residents, creating barriers to accessing good schools, jobs, and amenities, reinforcing existing social and economic divides. It's a complex feedback loop that planners and policymakers are constantly grappling with.
These are significant systemic issues affecting entire regions. But to really understand the nitty-gritty of implementation challenges on the ground, let's zoom in on that specific case study you mentioned from the Philippines, the municipality of Catil in Davao Oriental. Their study provides some very tangible insights into the hurdles communities face when trying to put plans into action.
You're right. The study on Catil provides a vivid illustration of common implementation challenges, especially in contexts that might have fewer resources. It uncovered critical insights, often categorized under the theme of challenges in urban growth, which frequently reflect, as the study puts it, a breakdown in governance.
A breakdown in governance. Okay, what did that look like?
Well, one of the foremost challenges they identified was simply enforcement. The core problem, as one respondent bluntly put it, is that people don't follow established land use rules.
Ah, non-compliance.
Big time. A specific example cited repeatedly was not adhering to 5-meter setbacks. Those required distances a building must be from a property line, crucial for ensuring light, air, space between structures, safety access.
Why weren't people following the rules?
A significant contributing factor seems to be the limited resources available to local government units, or LGUs, for enforcement. They might lack the staff, the vehicles, the technology to effectively monitor and enforce the rules across the whole municipality. One respondent plainly stated that enforcement is challenging since the government have limited resources for enforcement.
So capacity issues.
Exactly. This highlights that constant tension between plan development and individual actions and the very real practical difficulties faced by enforcement bodies, especially in lower resource environments.
Okay, so enforcement is tough. What else did they find?
Next, and perhaps even more pervasive and harder to tackle, is the issue of conflicting interests and weak political will. This is a deeply rooted problem where zoning implementation gets influenced more by political considerations than by strict adherence to the regulations themselves.
Politics getting in the way. Shocking.
Chuckles. Right. There's often a palpable lack of political will to robustly enforce the rules, especially if it means upsetting influential people or business interests. This, in turn, can lead to inadequate enforcement efforts and potentially weak regulations in the first place, rules with no teeth.
Any specific examples?
Yes, a striking one from the study mentioned the existence of structures in easement owned by elected officials and other business owners in the municipality. Easements are areas where building is typically restricted, like along rivers or roads, so having officials themselves violate the rules.
Undermines the whole system.
Completely. One respondent vividly described how political power is sometimes used to circumvent rules, highlighting how local officials might exploit their influence. Another noted simply, political influence influenced by political considerations rather than strictly adhering to the regulations. And this corroborates findings in broader research that political elements are at the core of zoning-related disputes, and that their misuse and manipulation can undermine the foundations of zoning. The Municipal Engineering Office, for instance, might not effectively regulate lot size, placement, density, and the height of some structures because of this political pressure.
Wow. That's a tough one to fix. What was the third major challenge?
Finally, Catil faced significant resource constraints more broadly. Beyond just having enough people for enforcement, a general scarcity of resources acts as a major impediment to effective implementation overall.
Like what kind of resources?
The study mentions inadequate resources like no plantilla position for zoning officer, zoning administrator, meaning there's no dedicated permanent staff member whose sole job is to manage zoning. It might be tacked onto someone else's duties.
So nobody's really owning it.
Potentially, yeah. And also a lack of essential equipment technology, maybe no up-to-date maps, no GIS systems, basic stuff. Moreover, even when existing resources are not utilized because many conditions and people are stubborn, even if told it's forbidden, like 5-meter setback, indicating that even when resources are present, public non-compliance driven by that lack of will or enforcement can render them ineffective. It's a vicious cycle.
Yeah, I can see that.
And these kinds of constraints, lack of staff, lack of tech, lack of political backup, can lead to significant project delays, increased costs, and managerial issues. Ultimately, it risks squandering financial resources and slowing down positive development activities, which ironically can contribute back to problems like unplanned urban sprawl.
That paints a very clear and, frankly, quite challenging picture of the real-world friction points. So if these are the pervasive challenges, lack of enforcement, political interference, resource scarcity, what about the solutions? How can communities bridge this gap between the plan and the reality, especially when it comes to involving the very people affected by these regulations? It seems like a lot of these implementation challenges ultimately come down to people not being fully on board, aware, or empowered. How absolutely critical is community engagement in making urban planning truly work on the ground?
You've hit on a crucial point there. It is absolutely vital. Community engagement is an indispensable component of effective urban planning. It's not just a nice to have, a box to tick. It's genuinely crucial for ensuring that the needs and aspirations of local residents are taken into account, and, maybe more importantly, for building the support needed for implementation.
So it's about buy-in.
Buy-in, legitimacy, relevance, all of it. Without genuine engagement, even the most technically brilliant, meticulously crafted plans can fail to gain traction, or worse, be actively resisted by the community they're supposed to serve.
Why is it so important, specifically?
Well, community engagement serves several multifaceted purposes. First, as you hinted, it's about building trust and legitimacy. When local residents are actively involved in the planning process, it helps cities build trust and demonstrate a commitment to transparency and accountability. People are much more likely to support decisions, even difficult ones, if they feel they've been part of the process.
Makes sense. Fewer surprises.
Exactly. Second, it's essential for ensuring relevance and effectiveness. Community input ensures that open policies and plans are actually relevant to local needs and contexts, rather than being top-down directives cooked up in an office that might completely miss the mark on the ground. Planners get invaluable local knowledge about how things really work.
The wisdom of the crowd, sort of?
In a way, yes. And third, it often fosters innovation and creativity. Community members bring unique perspectives and ideas to the table, lived experience, different backgrounds. This can lead to more innovative and creative solutions that might not emerge from a solely professional planning perspective. They might see problems or opportunities that planners miss.
That makes perfect sense. It's about tapping into that local wisdom and building a sense of shared ownership over the future of the place. But in a practical sense, how do communities actually get people involved? What are the mechanisms for participation, and are some approaches more effective than others at truly engaging the populace, not just the usual suspects?
That's the million-dollar question, isn't it? There's a whole range of mechanisms, from the very traditional to the more innovative and participatory.
Okay, like what?
Conventionally, we have public meetings and hearings. These are the standard forums where officials present proposed plans and policies, and community members can offer comments, ask questions. They're a baseline for public input, required in many places.
But turnout can be low, right?
Often, yes, and they don't always reach a diverse cross-section of the community. So beyond that, broader input is often gathered through surveys and other feedback mechanisms, online surveys, paper questionnaires, suggestion boxes. These allow residents to provide input on a wider range of issues, perhaps more conveniently.
Okay, moving beyond just meetings.
Right. Then you move towards more direct involvement. We see mechanisms like participatory budgeting. This is where the community gets directly involved in deciding how a portion of the public budget is spent. It allows them to have a direct say in how public funds are allocated for local projects, which can be incredibly empowering and educational.
Giving people real control over money.
Exactly. And then there are community-led planning initiatives. This is where local communities themselves take the lead, taking ownership of the planning process, maybe developing neighborhood plans that reflect their specific needs and aspirations, often from the ground up, perhaps with technical support from the city.
So bottom-up planning.
Right. Now, for any of these approaches to be truly effective, they require, as the source says, careful planning and execution. Just holding a meeting isn't enough.
What are the best practices?
Some key best practices include early and ongoing engagement. It's crucial to involve the community early in the planning process, not just presenting a finished plan for reaction, and maintaining ongoing dialogue throughout, not just one-off events.
Keep the conversation going.
Definitely. Processes must also be inclusive and accessible. They need to be designed to reach and engage all members of the community, including diverse socioeconomic groups, renters, young people, seniors, people with disabilities, different language groups. That means thinking about timing, location, childcare, translation.
Meeting people where they are.
Precisely. Clear and transparent communication is also paramount. Cities must openly communicate about the planning process, the proposals, the trade-offs, the outcomes, all in understandable language, avoiding jargon.
Yeah, jargon is a killer.
It really is. Finally, follow-up and feedback are critical for building long-term trust. Providing feedback to the community on how their input was used or why it wasn't, and following up on commitments made during the process reinforces trust and encourages people to participate again in the future. Nothing kills participation faster than feeling like your input went into a black hole.
That's a great point. Closing the loop.
Yeah.
Okay, this brings us to that real-world test case, and a particularly interesting one given its scale and complexity. India, with its massive urban growth, tried to basically mandate citizen participation through a community participation law. How did this ambitious initiative, particularly tied to the Jawaharlal Nehru National Urban Renewal Mission, or JNRM, unfold, and what did it aim to achieve on the ground?
India's experience with the Jawaharlal Nehru National Urban Renewal Mission, JNNURM, launched back in December 2005, is a really fascinating large-scale experiment in urban governance reform. The JNNRM was a massive program. It offered extensive financial, technical, and systemic support to Indian states to upgrade their cities.
Okay, big investment.
Huge. But here's the critical part, the string attached. It required the enactment of a community participation law, CPL, as a mandatory reform for states to receive those JNNURM funds.
A condition.
A major condition. The CPL's main objective was explicitly to instrumentalize citizen participation at the lowest level of governance of urban areas to push decision-making down.
How did they plan to do that? What was the structure?
The CPL aimed to fundamentally modify India's existing two-tier system of urban local governance, basically, the city-level municipality and the ward committees below that into a three-tier system. It proposed adding the Area Sabha, AS, or Mohalla Sabha, MS, essentially neighborhood councils as the lowest layer, positioned even lower than the existing ward committees.
The hyper-local bodies.
Exactly. These area sabas were intended to cover maybe 1 to 5 polling booth areas. They were supposed to have an elected representative, an ASR, chosen via secret ballot by the State Election Commission. And crucially, they were given important intended functions and duties.
Like what?
Things like deciding local development priorities for their area, preparing proposals to send up to the ward committee, identifying and verifying beneficiaries for government schemes, suggesting locations for public amenities like water taps or streetlights, assisting with public health services, and even supporting tax mapping. Their rights included getting information from officials and being informed by the ward committee about decisions affecting them.
So real tasks, not just talking shops.
That was the intention.
Yeah.
Now, the ward committees, WC, under the CPL, were also strengthened. They were to be constituted within 6 months of the municipality's formation. Their composition was key. All the elected area Sabha representatives from that ward would be members. The elected ward councillor would be the chairperson. Plus, they could nominate up to 10 civil society members.
Interesting mix. Elected and nominated?
Yeah. And their functions were pretty significant, too, assisting in preparing and implementing schemes, including big ones like solid waste management, supervising sanitation work, maintaining public spaces like parks, and assisting in tax collection.
And what about their powers?
This is where it got really interesting. Their rights included receiving information from the municipality, seeking budget clarifications from officials, and, quite remarkably, the power to potentially retain 50% of the ward revenue for development within the ward, at least until a predefined infrastructure standard was met.
Whoa! Control over money.
Significant potential control, yes. And they could even recommend penalties in case of misconduct of government employees working in the ward. Plus, they had duties to prepare annual ward development plans and budgets. This was clearly designed on paper to empower local communities with tangible responsibilities and some real financial autonomy and oversight.
Okay, that's the government's model CPL. But you mentioned an alternative.
Yes. In contrast to the government CPL, an alternative model, the Parivardan's Nagara Raj Bill, NRB, was proposed by Parivardan, a non-governmental organization known for its work on transparency and accountability. And this bill envisioned much, much more extensive powers and functions for citizen participation bodies. Comparing the two really highlights the tension between a more cautious, government-led approach to participation and a potentially more radical, grassroots-driven vision of empowerment.
How was the NRB different? What made it more radical?
Several things. First, the Mohalla Sabhas, MS in the NRB, were envisioned for smaller areas, maybe around 3,000 people, and could change their own boundaries by resolution. More fundamentally, the NRB included a right to recall.
Recall elected officials.
Yes. It gave voters the power to recall their Mohalla Sabha representatives and even the ward councillor through specific procedures, something entirely absent in the government's CPL. That's a huge accountability mechanism.
Definitely. What about money?
Big difference there, too. The NRB proposed substantial revenue powers for the Mohalla Sabhas themselves. They could receive 50% of the ward committee's share of house tax, and they could levy and collect their own taxes and fees on prescribed items, like parking or local advertisements, excluding housing. This contrasts sharply with the CPL's area Sabhas, which had no such financial powers at all.
So, real financial independence.
That was the vision. And the functions and duties for the Mohalla Sabhas in the NRB were incredibly broad. They were assigned responsibilities for managing essentially All activities mentioned in the 12th schedule of the Constitution, which lists typical municipal functions within their specific area. They would prepare annual plans, identify and verify beneficiaries with final say, not just suggesting, issue utilization and completion certificates for local works, ensure basic employment, health, and education for all residents, recommend police action, FIRs, be consulted on city master plans, recommend land acquisition terms.
Well, that's basically running the neighborhood.
Pretty close. They could even approve liquor shops and, critically, had the first right and control over all natural resources, like local water bodies in their jurisdiction. Compare that to the CPL's area sabas, which were mainly limited to assisting or suggesting.
Huge difference in scope. In powers.
Also much stronger in the NRB. Mahalasapas had the power to get any information from any official, hire their own consultants, direct and authorize expenditure from their funds, impose financial penalties on government officials under their control if they failed in their duties, recommend action to an ombudsman, summon officials to meetings, and even allow or disallow industrial activity or slum removal within their area with conditions.
Okay, that's serious power. What about the ward committees in the NRB?
They were also structured differently. NRB's ward committees were to be constituted only by all the elected Mahalasaba representatives, no nominated civil society members like in the CPL. Their term would match the MS reps. And their functions were more substantial, too, directly carrying out activities decided by the Mahalasapas, managing local institutions, receiving a significant chunk, 40% of state plan funds directly, and issuing utilization completion certificates for larger projects. They also had powers to manage their own employees, including transfers and salaries, and could impose penalties on officials who reported to them.
And the ombudsman, you mentioned that.
Yes, a critical provision in the NRB, entirely absent from the government CPL, was the proposal for a 3-member ombudsman in each municipality. This body would have powers similar to a civil court to investigate violations by officials or elected reps, impose penalties, and importantly, the ombudsman members themselves could be recalled by the Mahalasabas. It was a built-in accountability and grievance redressal system.
So on one hand, we had this incredibly ambitious bottom-up model proposed by Perverton, and on the other, the government's own CPL, which was still a significant step towards decentralization, but clearly less radical.
How did Indian states actually implement these reforms? Did they adopt the CPL as mandated? Did they live up to the promise of genuinely empowered local governance, or did the reality fall short?
Well, that's where the story gets complicated, and frankly, quite disappointing based on the research from 2011. The real-world status of CPL across Indian states highlighted significant shortcomings, even though 19 out of 31 states had technically enacted some form of community participation law to comply with the JNN-URM conditionality. The spirit often got lost in translation.
How so? What were the main problems?
One of the most glaring issues was the lack of area sapas altogether in several states. 4 states mentioned in the study, Manipur, Gujarat, Orissa, Meghalaya, quote, do not have any provision for constituting area sapas or any such kind of structure, directly violating the JNA-URM's core idea of establishing that 3-tier system for citizen participation at the grassroots level. So they just skipped the bottom tier.
Essentially, yes, in those cases. Furthermore, even where these bodies were created, many states failed to mandate elected area sabha or Mahalasabha representatives, opting instead for nominated ones, like in Karnataka, Hyderabad, Haryana. The concern here, as the study notes, is that nominated representatives would be loyal to their bosses instead of being responsible to common people, completely undermining the democratic intent. Only 3 states mentioned, MP, J&K, Assam, actually provided for elected representatives at that level.
Okay, so the structure was weak or missing in places. What about the powers they actually got?
That was another major problem area. The general trend across most states was to grant area sabhas and ward committees merely advisory or assistive roles rather than primary responsibility for functions. They had limited autonomy and power.
So back to being just talking shops.
Largely, yes. A critical issue here was the deep reluctance across states to transfer real budgetary functions and financial responsibilities. The study states starkly, no state gives responsibility to the AS to prepare the annual budget. For ward committees, 6 out of 9 states that even had WCs also did not assign them annual budget responsibility. And financially, none of the states provide a financial share to AS except MP that provisions to allocate a share of funds to Mahalasabhas.
So no money, no real power.
Pretty much. This meant these local structures often had to depend upon the municipality or governments to manage their expenses, making them completely dependent and lacking autonomy.
What about other rights and powers?
Mostly superficial rights and powers. While some rights were technically granted on paper, like seeking information, crucial powers, the kind seen in the NRB model, like directly implementing basic services, imposing penalties on unresponsive officials, or having real control over local resources, were almost always missing. In fact, Karnataka's act even allowed the ward councillor to veto any decision taken by the ward committee, effectively nullifying any potential local autonomy.
Wow, veto power.
Yeah, and most state laws were also silent on the provisions of removal of AS or WC representatives and did not propose any grievance redressal system like an ombudsman, leaving citizens with little recourse if things went wrong.
Any specific examples of weak laws?
The study highlights a few. In Madhya Pradesh, the Mahalla Samitis were defined as mere eyes and ears of the municipality, acting as subordinate organs with very limited functions and explicitly no right to seek information. In Gujarat, its law was seen as violating the very spirit of community participation by not even addressing area sabhas and retaining a purely advisory ward committee structure from a much older 1949 act without any real citizen inclusion. Maharashtra didn't provide for election or nomination of AS representatives, made the councillor the chairperson, and had no ward committees or any institutions similar to it at the time of the study.
So it sounds like widespread reluctance, maybe.
That seems fair. The stark conclusion of the study was that all states' laws, in their present form, are not likely to make any impact on the ground in enhancing citizens' participation, and that states had essentially not been honest in complying with the mandatory requirements of the JNN-ORM. It truly highlights the complex political and administrative hurdles, the resistance from existing power structures, perhaps, to translating ambitious policy into effective, on-the-ground change that genuinely empowers citizens.
It's clear that while the idea of empowered community participation is often embraced rhetorically, the execution frequently falls short, particularly when it comes to embedding it in legal frameworks and allocating tangible power and resources. This fundamental struggle between central authority and local autonomy brings us to a deeper, more theoretical understanding of how legal principles themselves define these power dynamics in urban planning.
That's right. We've seen the practical challenges, but underlying all of this is a complex legal architecture. Planning law is inherently complex because it's so intricately intertwined with both legal principles and political realities. At the very core of legal analysis in planning is this concept of legal legitimacy.
Legal legitimacy,
Yes.
meaning
The fundamental justification for public intervention for the government stepping in and regulating private land use. Without this established legitimacy, any attempt by the government to dictate how private land is used could be seen as arbitrary, an overreach, an infringement on fundamental property rights.
Okay, so where does this legitimacy come from?
Well, the historical quest for this legitimacy in the U.S. context is really well illustrated by that landmark Supreme Court case we touched on earlier, Euclid v. Ambler back in the 1920s. That case famously confirmed the legitimacy of zoning as a valid exercise of the state's police power under the U.S. Constitution, the power to regulate for public health, safety, morals, and general welfare.
So that case basically said zoning is okay, constitutionally.
It established that crucial precedent, yes. But this quest for legitimacy isn't just a historical footnote. It continues globally whenever new, potentially more restrictive planning tools are introduced. For instance, the source mentions when South Korea implemented its Green Belt policy in the 1970s, which radically prohibited almost all development activities within designated zones around cities to prevent sprawl, it immediately faced constitutional challenges. People argued it was an excessive infringement on their property rights, that the government had gone too far, so the legitimacy question is always potentially present.
Okay, so what are the big legal questions that planning frameworks have to grapple with everywhere?
Legal frameworks in urban planning essentially try to answer some fundamental questions about this government intervention. First, who limits it? Which level of government or administrative agency actually holds the planning authority? Is it the central government, state or regional government, or local municipalities? How decentralized is the system in practice?
Who's in charge?
Exactly. Secondly, how much it can be limited. This explores the extent to which land use can be restricted before it undermines fundamental property ownership rights. This gets into complex legal doctrines around takings. When does a regulation go so far that it effectively takes the value of the property, requiring compensation? It also involves the fundamental relationship between simply owning land and possessing the development rights. Does owning land automatically include the right to build whatever you want on it? Different legal systems answer that very differently.
Right. Development rights aren't always inherent.
Often not. Thirdly, there's the question of how to limit it. What are the specific planning tools and procedures that are considered legitimate? Does the government intervene passively, mainly by setting standards and rules, like typical zoning? Or does it intervene more actively, perhaps through public land ownership, land banking, or directly undertaking development itself?
Different tools in the toolbox.
Precisely. And the binding force of the plans themselves is also crucial here. Are the plans just aspirational documents, or do they have real legal teeth? This determines if they're more than just meaningless documents. We mentioned earlier how U.S. comprehensive plans were historically non-binding, but are increasingly becoming binding in many states, which marks a significant shift towards plans having more direct legal weight.
Okay. And what if owners disagree with the rules?
That's the final key question. Challenging restrictions. How can property owners or even citizens challenge these planning decisions or restrictions? What are the available dispute resolution models? Is it through specialized planning inspectors, like in the UK, administrative appeals bodies, or ordinary lawsuits in the courts? And critically, what is the court's review standard? How closely will a court scrutinize the substance of a planning decision? Will it defer heavily to the planner's expertise, or will it conduct a more thorough review? This determines how much courts can actually intervene in the contents of a plan. These big questions really form the backbone of planning law everywhere.
This gets really interesting when you start comparing different countries, doesn't it? You begin to see how different legal traditions, different constitutional setups, different societal values about property and community manifest in their planning systems. Are there common legal contexts or maybe underlying tensions that consistently shape planning laws globally, giving each system a kind of unique legal fingerprint?
Absolutely. When scholars try to compare urban planning laws across different jurisdictions, they often look at what one source calls 5 embodied contexts. These aren't rigid categories, but rather lenses or key dimensions that help us understand the similarities and differences in how planning law functions. They focus particularly on the interaction or the inherent tension between the key players involved: the property owners, the government, planning authorities, and increasingly third-party citizens or community groups.
Okay, what are these 5 contexts?
The first context is the strength of property rights. This basically examines the extent to which private ownership is understood to encompass development rights. Conversely, it looks at how much discretionary power the planning authority can exercise over private land. The more strongly development rights are recognized as belonging to the owner, the less flexible the planning authority typically becomes, and the more likely restrictions are to be challenged as takings.
Can you give examples?
Sure. The source contrasts countries like Sweden, which has been described by some scholars as having effectively abolished development rights for owners, meaning permission to develop is granted by the state, not inherent in ownership, with the UK, where historically all development rights were nationalized by the Town and Country Planning Act of 1947. The state essentially took control of the right to develop.
Very different starting points.
Hugely different. And this often reflects deeper philosophical foundations contrasting, say, the more individualistic notions of property ownership, arguably prevalent in the USA, influenced by thinkers like J.S. Mill, with systems emphasizing the social obligations of ownership, perhaps more influenced by Hegelian ideas in Germany, where property ownership comes with inherent duties to the community. It also involves looking at whether certain social classes or groups receive greater property protection against planning interventions than others.
Okay, strength of property rights. What's the second context?
The second is the level of judicial intervention. This assesses how much and how often courts get involved and influence the operation of the planning system. Generally speaking, less judicial intervention tends to mean greater initiative and discretion for the planning agency, as they're less likely to be second-guessed by judges.
So how much do courts step in?
It varies greatly. In the USA, for example, local land use decisions often benefit from what's called a highly deferential rational basis or rational relationship review from the courts. This means courts are often reluctant to overturn planning decisions as long as the government can show some rational connection between the regulation and a legitimate public purpose. It's a relatively low bar. This also involves who has the burden of proof. In a legal challenge, typically it's on the challenger, the property owner, in the USA to prove the regulation is invalid, though some state Supreme Courts have shifted that burden somewhat in certain cases.
So courts might not dig too deep into the planning details.
Sometimes not. The source notes that even where legal principles for review exist, courts in some countries, like South Korea, it suggests, have been criticized for tending to omit detailed analysis of interests in practice and thus effectively refuse to exercise judicial control over planning in many cases. This context also includes looking at alternative dispute resolution mechanisms beyond traditional courts, like mediation or planning appeals boards.
Got it. Judicial role. Third context.
Third, we look at whether a system is fundamentally plan-led or development-led. This distinguishes systems based on the importance and, crucially, the binding legal status of the comprehensive plan itself.
Okay, how does that work?
A strongly plan-led system is one where the comprehensive plan has explicit, detailed, and strongly binding contents that are difficult to amend or deviate from during the implementation phase, when individual development permits are considered. In such a system, the process of establishing the plan itself is absolutely central as it locks things in.
And development-led.
A development-led system, conversely, might have plans with less clear, more general, or weaker legal contents. This allows for more clarification, negotiation, and modification during the processing of individual development applications. The focus shifts more to the permitting stage rather than the plan itself. The UK is often traditionally seen as having a less binding plan and planning permission system, sometimes described as more development-led or discretionary, although recent reforms have tried to strengthen the role of plans. Korea, on the other hand, is cited as having binding city plans that control over the permission, suggesting a more plan-led approach. But it's noted that even theoretically plan-led systems, like the former system in the Netherlands, can become more development-led in practice if plan modifications are relatively easy to obtain.
So plan's power. What's number 4?
Fourth is the allocation of planning power. This examines who actually controls land use decisions and to what extent. Specifically, it looks at how planning authority is allocated between central and local governments. Is it top-down, bottom-up, or some hybrid? And importantly, what is the possibility and effectiveness of central government intervention in local planning matters?
Central versus local control.
Exactly. In Japan, for example, the City Planning Act allows the national minister to intervene directly in local city planning decisions if it's deemed necessary for the national interest, demonstrating clear top-down characteristics despite general decentralization trends. In Korea, we mentioned the Green Belt was designated by the central government, another example of central power. In the UK, while local authorities manage the specifics of the Green Belt around cities, the overall national planning policy framework established by the central government exerts significant control over it.
So central government often keeps some control.
Often, yes, even with decentralization. This context also looks at the incentives facing local governments, like the desire for tax revenue or investment, which can significantly affect how they use any planning power that is delegated to them. There's also a noted global trend towards decentralization of planning authority, seen in the USA, South Korea, Japan, but central intervention often still exists alongside it.
Okay, property rights, courts, plan status, power allocation. What's the fifth context?
Finally, the fifth context is the level of participation. This marks the significant evolution of planning from what was traditionally seen as a two-dimensional relationship just between the administrative agencies, the planners, and the property owners, whose land was being regulated to a much more complex three-dimensional relationship that additionally involves ordinary citizens and community groups as active players.
Bringing the public in.
Exactly. Citizen opposition, as we saw with the India example, can significantly prevent or delay planning changes, illustrating their growing influence. While the traditional police power justification in the USA promotes public health, safety, morals, and the general welfare, it raises interesting legal questions about whether land use can be restricted based purely on personal preferences, such as citizens' preferences, about neighborhood character, for example.
The MBY factor.
That's often part of this dynamic, yes. Public engagement procedures like public hearings, consultations, notice requirements are increasingly mandatory in planning processes worldwide. Their omission can even render a plan legally unlawful. And you see further extensions of citizen involvement, like the concept of electoral zoning in some parts of the USA, where certain planning decisions or plans themselves might be subject to a referendum vote by the public.
Direct democracy in planning.
In some cases, yes. What's fascinating here, as the source emphasizes, is how these five elements, the strength of property rights, the role of the judiciary, whether the system is plan or development led, where planning power resides, and the degree of citizen participation, all interact dynamically. They combine to create a unique legal and political fingerprint for urban planning in each specific jurisdiction.
And comparing them isn't about finding the best system.
No, the purpose of comparative planning law isn't really to find a single better solution that can be universally applied. Instead, it's more about understanding the motive for devising a solution in a particular context, understanding why a system is structured the way it is by analyzing how different systems adapt to these inherent tensions, like property versus public good, central versus local, expert versus citizen, and respond to evolving societal needs and values.
That makes sense. It's about understanding the trade-offs. Now, this whole journey through the evolution of planning from the Industrial Revolution's chaos, through comprehensive plans, legal battles, community involvement struggles, now takes us to a brand new frontier, doesn't it? Where technology is fundamentally changing how cities operate and are governed. Let's explore how smart cities are introducing a whole new set of legal and governance challenges. This really does feel like a whole new frontier in urban development, doesn't it? We're hearing more and more about smart cities. What exactly does that term mean in this context? And how does this digital revolution throw a wrench, potentially, into the existing urban policy and legal frameworks we've been discussing? It seems like a whole new set of considerations, not just physical, but digital infrastructure data.
It absolutely is a new frontier, and it truly does introduce a significant new layer of complexity, opportunity, and risk to urban governance. When we talk about smart cities broadly, we're referring to technology-driven urban developments primarily aimed at enhancing city efficiency, sustainability, and livability.
Using tech to make cities work better.
That's the core idea. Their fundamental reliance is on information and communication technologies, ICT, and the Internet of Things, IoT. This means deploying vast networks of sensors embedded in infrastructure, leveraging data from transportation systems, utility grids, buildings, even citizens' devices, to collect and analyze massive amounts of real-time or near real-time data.
Data is key.
Data is the fuel. This data, in turn, is supposed to inform decision-making, allowing cities to respond more quickly to problems, optimize resource allocation, and ultimately improve the delivery of public services.
What are the promised benefits? What's the sales pitch?
The potential benefits often highlighted are quite significant. First, improved efficiency and productivity. For instance, the idea is that smart traffic lights can dynamically adjust timings to reduce congestion and improve travel times, making commutes smoother and reducing emissions. Likewise, smart energy grids can help reduce energy consumption and costs by optimizing energy distribution, integrating renewables, and identifying inefficiencies faster.
Okay, efficiency. What else?
Enhanced quality of life for citizens is another major goal. Examples often cited include smart parking systems, making it easier to find available parking spaces in crowded urban centers, reducing frustration and circling time. Or smart waste management systems that can reduce waste collection costs and improve sanitation by using sensors in bins to optimize collection routes based on actual fill levels.
Convenience and cleanliness.
Right, and critically, especially now, they aim for increased sustainability. Smart energy grids, as mentioned, can better integrate renewable energy sources and reduce greenhouse gas emissions. Smart water management systems using sensors can help reduce water consumption and waste through precise monitoring and rapid leak detection.
So greener cities, too.
That's definitely part of the promise. As a real-world example, the source mentions Kota, India, as one of the cities selected under India's Smart Cities mission, which has been actively developing initiatives in smart transportation, energy, water, and governance to try and harness these potential benefits.
Okay, these benefits sound incredibly promising, almost utopian in their vision of smooth, efficient, sustainable urban living. But as we know, from a legal perspective, new technologies often bring new complexities and expose gaps in existing laws, don't they? What are the biggest unique legal or regulatory obstacles that smart cities face when trying to apply current regulations or figure out the new rules needed?
You're absolutely right to point out the complexities. While the potential benefits are compelling, smart cities inherently present a number of unique legal and regulatory challenges that our traditional urban planning and governance frameworks simply weren't designed to handle effectively.
Like what? What are the main headaches?
Well, the first and perhaps the most prominent and publicly debated challenge is data privacy and security. The very nature of smart cities involves the extensive collection, aggregation, and use of data from a vast array of sources, sensors monitoring traffic flow, cameras for public safety, utility meters tracking consumption, even data from citizens' smartphones interacting with city services. This raises significant privacy concerns for citizens.
Yeah, the surveillance city fear.
That's definitely part of the conversation. There's this constant tension between collecting enough data to make the systems work effectively and protecting individual anonymity and preventing intrusive surveillance. Plus, there's the very real potential for data misuse if it falls into the wrong hands, or major security breaches if these complex systems aren't adequately protected from cyber attacks.
Okay, privacy and security, huge. What else?
Then there's the incredibly complex issue of liability. The deployment of all these interconnected new technologies inevitably creates new liability risks. The source poses a critical question. Who is liable if a smart traffic light system malfunctions and causes an accident?
Good question. Who is liable?
Exactly. Is it the city government that operates the system? Is it the private technology provider who supplied the hardware or software? Is it the sensor manufacturer whose device failed? Maybe the company that maintains the software algorithms. Existing tort law and municipal liability rules often don't provide clear answers for these complex, multi-party technological systems.
A legal gray area.
A big one. Intellectual property, IP, is another significant area of complexity. The development and deployment of smart city technologies often involve cutting-edge innovations and complex IP rights, patents on sensors, copyrights on software, trade secrets, and algorithms. This requires clear frameworks on ownership, licensing, and the sharing of these innovative solutions, especially when you have collaborations between multiple private companies and public entities all contributing different pieces. Who owns the data generated? Who owns the insights derived from it?
Lots of thorny IP questions.
Definitely. And finally, compounding all of this, we often face the challenge of regulatory fragmentation. As the India study highlights, the existing legal landscape relevant to smart cities is frequently fragmented. There isn't usually one single coherent law governing smart cities. Instead, you have a patchwork of different laws and regulations: data protection laws, procurement rules, telecommunications regulations, transportation laws, cybersecurity rules applying to various aspects of smart city development. This patchwork can make coordination, compliance, and implementation incredibly difficult and confusing for city officials and the technology companies they partner with. It hinders the seamless integration that smart cities ideally promise.
So it sounds like we're trying to fit this square peg of cutting-edge, interconnected digital technology into the round hole of often outdated, siloed analog-era regulations.
Yeah.
Are our current legal frameworks in cities actually equipped to handle these new digital realities, or are they lagging behind, potentially creating obstacles to the very innovation and effective governance that smart cities aim for?
That's precisely the concern raised by the research, particularly the study focusing on Kota, India. The findings strongly suggest that, in many cases, the existing legal frameworks are lagging behind and are indeed fragmented and incomplete.
Fragmented and incomplete.
Yes. The study found that Kota, like many cities embarking on smart initiatives, lacks a single law or regulation that specifically addresses the unique needs of smart cities. Instead, as we discussed, government officials and technology companies must navigate that confusing patchwork of different laws and regulations, which makes it incredibly difficult for them to understand their obligations, ensure compliance, and move projects forward efficiently. It creates uncertainty and potential roadblocks.
What other specific problems did that study find?
A significant practical issue identified was the lack of clarity on roles and responsibilities. There's often a profound lack of clarity on the roles and responsibilities of different stakeholders involved in smart city governance: the various city departments, state agencies, private tech vendors, infrastructure providers, citizens. For instance, the study notes it's frequently unclear who is responsible for collecting, managing, and using data generated from smart city technologies. This ambiguity can easily lead to turf battles, disputes between public and private partners, finger-pointing when things go wrong, and ultimately project delays that hinder progress.
The governance confusion.
Right. Furthermore, the research highlighted that the current framework, at least in the case studied, does not adequately address privacy protection. It found that existing laws fail to provide clear guidance on how to protect the privacy of citizens, specifically in the context of pervasive data collection by smart city technologies. This leaves a significant gap in safeguarding fundamental individual rights in this new technological environment.
And what about innovation? Does the legal situation help or hurt?
According to this research, it can actually hurt. The existing complex and uncertain regulatory environment can discourage technology companies from investing in and developing new smart city technologies. If the rules are unclear, if liability risks are high and undefined, if navigating the bureaucracy is too cumbersome, companies might hesitate to bring their best innovations forward or invest heavily in a particular city. This directly hinders the very innovation that is crucial for smart cities to reach their full potential.
So the legal framework itself can become a bottleneck.
It seems so. These findings really underscore the urgent need for a specific legal framework for smart city governance, one that is designed proactively to address the challenges unique to these technologically advanced urban environments, rather than just reacting after problems arise. The research also strongly emphasizes that smart city governance shouldn't just be about technology. It must be collaborative and inclusive, ensuring all stakeholders, from citizens to tech companies to various government agencies, have a meaningful voice. And fundamentally, it must prioritize transparency and accountability in all its operations, especially concerning data use and decision-making.
Okay, so if the current frameworks often aren't quite ready for this digital leap, what does a truly smart legal framework look like for a smart city? What
Brilliant.
practical recommendations are emerging for paving the way forward, ensuring these promising technologies can truly flourish and serve their intended purpose without us getting tangled in legal uncertainty or compromising citizens' rights?
The research, based on the challenges identified, offers several practical and forward-looking recommendations for reforming the legal framework for smart city governance. These are aimed at creating a more enabling environment.
What's the top recommendation?
First and foremost, there's a clear call to develop a comprehensive legal framework. This means moving beyond the current patchwork. Cities or higher levels of government need to create a specific, unified framework that directly addresses all those key legal challenges we've discussed. Data privacy and security standards, clear rules on liability allocation, guidelines for intellectual property sharing, and public-private partnerships. It needs to be holistic.
Get it all under one umbrella, sort of.
Ideally, or at least ensure coherence across different laws. Alongside this comprehensive framework, it's crucial to establish clear and transparent regulation specifically for the deployment and operation of smart city technologies. This regulatory framework should be built on clear principles of fairness, non-discrimination, transparency in how algorithms work, where possible, and robust accountability mechanisms. This provides predictability for technology companies and helps build public trust.
Makes sense. What about the people side?
Absolutely critical. Another key recommendation is to promote meaningful public participation. Citizens must be actively involved not just as data points, but in the development and implementation of smart city initiatives from the beginning. This ensures they have a genuine voice in deciding what technologies are deployed, how their data is collected and used, what the priorities are, and that they can hold government and its partners accountable for the outcomes and any negative impacts. This means moving beyond mere token consultation to genuine co-creation and oversight.
So building on the community participation theme we discussed earlier,
Exactly, applying it to this new technological context. It's also vital to invest in capacity building. Government officials, city planners, legal staff, and other stakeholders often need new skills and knowledge to effectively manage complex smart city initiatives. This includes understanding the technology itself, the evolving legal and ethical implications, data management best practices, and how to effectively engage communities around these sometimes technical issues. Training is key.
building the human capacity alongside the tech.
Precisely. Finally, there's a strong emphasis on the need for cities to collaborate and share best practices. Smart city development is still relatively new and rapidly evolving. Cities should actively learn from each other's successes and, just as importantly, their pitfalls and failures. By sharing experiences, data, and model policies, they can avoid reinventing the wheel, overcome common challenges more quickly, and accelerate positive development, building on collective knowledge rather than working in isolation.
That seems like a smart approach in itself. This whole journey, then, through the evolution of urban planning, from dealing with the initial chaos of the Industrial Revolution to crafting comprehensive plans, navigating intricate legal battles over local control and property rights, wrestling with community participation, and now confronting the digital challenges and opportunities of smart cities. It really brings home how foundational and absolutely critical these frameworks are to shaping our collective future, doesn't it? So thinking about everything we've covered, what's our big takeaway from this deep dive? Hashtag TechShack outro. What a journey. We've really navigated the intricate, sometimes messy world of zoning and urban planning today. We went from its historical roots in trying to manage industrial chaos through the creation of foundational comprehensive plans. We looked at the very real challenges of implementation on the ground, the absolutely critical role of community participation or the lack thereof, and then right up to the cutting edge of smart cities and the whole new set of legal frontiers they represent. Looking back at all that, what's the core message, the essential nugget of insight you'd want our listener to walk away with today?
I think the core message is this. Zoning regulations and comprehensive planning are far, far more than just dry bureaucratic rules filed away somewhere. They are truly indispensable tools for trying to foster orderly, ideally sustainable, and hopefully equitable urban development. They shape our physical world in profound ways.
But there's a but.
That was big but. Their true effectiveness really hinges on overcoming those persistent challenges we discussed, namely, that constant tension in balancing top-down expertise and directives with authentic local needs and participation. It's about navigating complex political realities and influences. It's about securing adequate resources, staff, funding, technology. And crucially, it's about ensuring genuine, empowered citizen participation, not just token gestures. And the legal frameworks underpinning all these efforts, they're not static. They can't afford to be. They must be dynamic and adaptable, ready to evolve, especially as brand new complexities like those introduced by smart city technologies continue to emerge and reshape our urban environments. It's really an ongoing, living process of shaping our communities, not a finished product.
This deep dive really does make you think differently about the cities and towns we live in, doesn't it? About the decisions, big and small, visible and invisible, that shape them over time, and just how deeply interconnected planning, law, politics, and community truly are. So for our listener, maybe something to mull over, perhaps a final provocative thought to spark some further curiosity about their own community's future, building on what we've discussed.
Absolutely. Here's something to consider as you walk or drive around your own neighborhood or city next time. Given everything we've discussed today about that delicate balance between the strength of private property rights versus the public good, the level of intervention by courts, whether your local planning system feels more driven by a long-term plan or by individual development deals, how planning power is allocated between your local government and maybe state or regional bodies, and, most importantly, the level and effectiveness of citizen participation. What one specific change in your local zoning code or your community's comprehensive planning process do you personally believe would have the most profound positive impact on your community's future trajectory, maybe towards more affordability, better walkability, greater sustainability, or more equity?
Okay, one big change.
And then perhaps the more challenging part of the question. What specific legal, political, or social hurdle do you anticipate would make that particular change, the one you just identified, so difficult to actually achieve in your community? What's the biggest roadblock? Thinking about that might reveal a lot about how planning really works where you live.